Hi, and welcome to Holland Estates. You're listening to episode 603. I'm Paul Trudelle.
I'm Nick Esterbauer.
Hi, Nick. How are you today?
I'm doing well, thanks, Paul. How are you?
I'm good. Staying safe, staying healthy as possible, and isolating to the extent possible.
Yep. So we're both podcasting from home today and making good use of this technology that's becoming more and more prominent in our practices.
So prominent and so important to get comfortable with. I just finished approximately a 2-week trial where it was all done on Zoom. And I think we're going to be seeing a lot more of that. And I guess that segues into our talk today, which is with respect to recent changes to the rules of civil procedure that will come into effect January 1st, 2021, that deal with a number of issues, including virtual appearances. So maybe we'll talk a bit about those rule changes. And this is an amendment to Ontario Regulation 689/20, if you want to look it up, and we'll put a link to that on our website. It deals with a number of rule changes that modernize the rules of civil procedure and bring them into our new way of practicing. And I think it's clear from the rule changes that these changes will persist beyond our pandemic, and it's a new way of doing business for all of us. So maybe we can talk about one of the changes, which is the method of attendance at a hearing. Rule change there is that when you commence a proceeding or you're going to commence a hearing through a notice of application or a notice of motion, that you specify how the hearing is to be held. And you propose that it be either held in person, by telephone conference, or by video conference. And that's something that the party who is proposing the hearing puts out in the document, the notice of motion or notice of application.
And I guess recently, Paul, you mentioned you had just done a trial was entirely virtual. A lot of the scheduling appointments we've been doing on the Toronto Estates list have been, I believe, by Zoom, unless it's been requested otherwise. So this is something that's consistent with what we've been seeing in the courts already, but clarifies sort of, the process for either choosing or objecting to the method of the hearing.
Right. Yes. So that was, I guess, the Zoom calls that we've been having to date have been in accordance with the practice direction. It's now in the rules. You can specify that you want a video conference. If somebody opposes that, they can file a notice of objection to that. And there's a document, a pre-printed mandated form for objecting. And the court will then have a telephone conference in order to determine how the matter is to proceed, whether in person or by way of video conference. And part of the rule amendments, though, deal with the issue of costs. And if you object unnecessarily, the court can award costs for your unnecessary or inappropriate objection to a video conference or telephone conference. So I think that we need to think about how the hearing is to be held, why it needs to be held in person, if it's going to be held in person, and have some solid reasons for that. Keeping in mind a lot of the case law that we've seen during the pandemic that deals with what matters can be heard virtually and how the court can deal with things virtually. I think the court's comfort level with respect to virtual hearings is high. And I think, therefore, the courts will, that may be the default going forward unless there's some reason not to go by way of a video conference hearing.
So in dealing with these objections, it sounds like the court's going to be considering things like the general principle that evidence and argument should be presented orally in open court, the importance of certain witnesses, whether their credibility be assessed in person or if that's something that can be done virtually. I was trying to think, Paul, situations we deal with trials and certain, I guess, scenarios where you would want to do an in-person trial. I wonder if maybe were there allegations of undue influence, matters like that, where maybe an in-person examination may make more sense.
I think that may be the case, although I just saw an article in the Advocate Society Journal about assessing credibility over, virtual hearings and how that can be done. And there's no handicap to trier of fact in making those determinations, even if it is done virtually. Safeguards are always put in place to ensure that the person's not being prompted, doesn't have access to documents that they shouldn't be looking at. And I think the court can make those determinations of credibility over Zoom. So I don't know if that's going to be a strong objection to having a hearing proceed virtually. I think it'll have a lot to do, though, with the judge's comfort level with respect to proceeding by way of Zoom. We had the benefit of having a judge in the trial that I was just at, if I can refer to that again, who was very comfortable with the electronic platform and proceeding by way of a virtual trial. Other judges may not have that comfort level and may therefore lean towards an in-person hearing.
So some other matters that are covered by this change in the rules are mandatory mediations and discoveries as well. So that's something I know a lot of us have been doing by Zoom or other manners of video conference, and it's something that's going to continue to be relevant in the future.
Right. So if you want to proceed with a mediation or examination virtually, then you can propose that. It's up to the person. If the other side doesn't agree to that, they'd have to come up with some solid reasons why it shouldn't be done virtually. Another significant change that's been receiving a lot of attention on Twitter, Zoom, is not the abolishment, but the abandonment of fax service. Fax numbers are no longer required on any documents that you prepare or file with the court. Service by fax is no longer an acceptable manner of service, and there's provisions that deal with service by way of email. Email service is accepted. You don't need prior consent to serve a document by email. So I think that's an important change that's going to have a significant effect on, I guess, the fax machine industry in Ontario.
Absolutely, and it'll be nice to avoid sending out, couriers to deliver documents in hard copy, where we can be doing service by email instead for documents other than originating processes.
Right. Yep. And documents can be filed electronically as well. There's some changes to the standards for documents. The size of print remains the same, and it's to be printed on good quality paper. However, there's also additional rules that provide for the format of electronic documents that you're filing with the court. They must comply with those requirements as far as being legible, and also any other requirements required by software. The other thing that is new in the rules is reference to case lines, which is software authorized by the Ministry of the Attorney General for the purposes of this rule, and is available on the internet under the name of case lines. Documents need to be filed. Certain documents, and they're specified in the rules, need to be filed with case lines, and that allows the judge to access the documents for hearings. There's a repository of those documents that can be referred to during a hearing.
Another update to the rules I find interesting is the expansion to the types of motions that may be brought in writing. Rule 37.12.1 sub 4 is being amended to allow for opposed motions in writing, even where there are issues of fact or law that are more complex than we typically see in motions in writing for now.
Yeah, and it'll be interesting to see how that rule is picked up and to what extent motions in writing are going to be carried out. I like the idea of motions in writing, but I think that there's a loss when you don't have that opportunity to react to a judge's concerns or react to points raised by the other side, on your feet. So I'm not sure how broadly or widely used that rule will be. It may be appropriate where there's distinct legal issues where written submissions can address the points, or where there's just a very narrow issue in dispute, perhaps in an order giving directions, and you want to make submissions on a particular point that you can't reach agreement on. Other changes I think that are important are the virtual commissioning of affidavits. We've been doing that for some time, but it's now codified or accepted or seen as an appropriate practice in the rules. So that's good that the rules have caught up with our practice with respect to virtual commissioning of affidavits. And on that point, I think to address the practicalities of getting documents back from the court, the rules allow for electronic signatures by a court, a registrar, or a judge, and those are acceptable signatures on documents. The rules also provide for how orders can be entered by way of emailing it in, getting it signed and returned, and an electronic copy of the document is operative and effective. I don't know if there's any other points that we should highlight. I think that may be enough for today. We'll put, as I said, the link to the rules up on the court. I don't know what's going to happen to our rules of civil procedure. I already have 2021, and they're probably some partially obsolete now. I don't know if we'll get another version of that, but we'll see. But I think we have to at least note up our copy of the rules to make sure that we're aware of the new rules and filing requirements and other changes made by this pretty broad-reaching amendment. Well, thank you for listening. Enjoy the rest of the year as 2021 winds down, and stay safe. Till next time, I'm Paul Trudelle.
I'm Nick Esterbauer.
And if you have any comments, please go to our webpage. We have an email address link there and send them to us, and we'd be happy to respond or address any of those issues. Thank you.